This is Left Voices for Thursday, April 17th, 2014. I'm Andrea Sears. Tonight,
there is room to argue, and Mr. Noble's attorneys are in fact arguing, that this type of sentence in Louisiana violates the state constitution's prohibition on cruel and unusual punishment.
A Louisiana man is sentenced to 13 years hard labor for possessing 2 joints. A number of civil rights and drug policy reform organizations have filed an amicus brief asking the Louisiana State Supreme Court to review the extraordinarily harsh prison sentence imposed on Bernard Noble. Noble was arrested in 2010 for having 3 grams of marijuana, about enough to roll 2 cigarettes. The trial judge sentenced him to 5 years in prison. But because Noble had 2 other minor nonviolent drug possession charges on his record, one of them from 20 years ago, the prosecutor insisted that he be sentenced under Louisiana's habitual offender law. His sentence was ultimately increased to 13 1/3 years at hard labor with no chance for parole. Daniel Abrahamson, director of the Office of Legal Affairs for the Drug Policy Alliance, says the judge who presided over the trial had flatly refused to apply that maximum available sentence.
His sentencing judge said it shocks the conscience that I would be asked, much less forced, to impose a sentence of 13 1/3 years for this very minor crime. The district attorney, however, of New Orleans said, you know what? The statute says that I can ask for 13 1/3 years, and I'm going to ask for that full amount of time, and I'm going to ask the appeals court to overturn your still long sentence of 5 years, but ask them to overturn it on the grounds that you have no discretion but to impose a 13 1/3 year sentence. And so the prosecutor appealed to the Intermediate Court of Appeals, and even that court said no, 13 1/3 years is excessive, and the prosecutor said, well, I think you're wrong too. I'm going to appeal to the Supreme Court and make them impose a 13 1/3 year sentence. And in fact, the prosecutor eventually was able to get 4 votes of the 7 on the Louisiana Supreme Court to overrule the trial court's decision. And now we're back up in front of the state Supreme Court asking them to really reconsider their decision. So it's really been the prosecutor pushing this time and again over the objections of 2 different sentencing judges, all 3 intermediate appellate court judges, and 3 of the 7 Supreme Court justices. So we have 8 judges of the 12 judges who've looked at this case saying this is obscene, this is ridiculous, that we're imposing this kind of sentence for this type of crime. And yet this prosecutor at this point has 4 votes in the state Supreme Court, and that's what he has needed in the past.
Did the prosecutor present a case as to why he thought the 13 1/3 years was justified, considering the length of time between these minor drug convictions and the really minor offense that he was convicted on for the 3rd offense?
No, the prosecutor has not presented a case on why this Mr. Noble deserves to be in prison for 13 1/3 years. What the prosecutor has done instead is simply say that the Louisiana legislature has passed a sentencing statute that authorizes this type of sentence for somebody like Mr. Noble who has these prior convictions, and therefore just reading this habitual offender statute on its face, that type of sentence is allowed. We as a prosecutor are going to demand that that type of sentence be imposed. So that's the argument they've made. They've also made a further argument that the defense attorneys for Mr. Noble have not presented sufficient evidence on why Mr. Noble should get any particular relief from a 13 1/3 year sentence. And so those are the 2 arguments they've made.
The Drug Policy Alliance has filed an amicus brief in this case. What is your argument? How are you presenting this to the court?
Well, the Drug Policy Alliance is representing several amicus organizations or Friends of the Court organizations, including 2 religious-based organizations, the Reason Foundation and the ACLU of Louisiana, in addition to the Drug Policy Alliance. These organizations represent a broad swath and broad range of viewpoints and backgrounds, but they're all agreed on the following, that this sentence of 13 1/3 years for Mr. Noble is excessively egregious, is not justified, and what the point of the brief is in front of the Louisiana Supreme Court is to provide the court with additional information that Mr. Noble's attorneys are unable to present for lack of space and lack of time about how Louisiana is far out of step with almost every other state in the country in terms of their sentencing policy. How Mr. Noble would not be given a sentence anywhere near this amount in any other state were he to be caught and convicted in another state, and how wasteful and inappropriate this type of sentence is in Louisiana. Then brief also raises the point that it's not surprising, frankly, that Mr. Noble is an African-American man who's being victimized by this type of sentencing law, insofar as marijuana laws have been disproportionately enforced against African-Americans, particularly in Louisiana.
That is one point that is raised here, that the impact of marijuana possession laws in Louisiana comes down particularly harshly on African Americans, as it does across the country, but in Louisiana it seems especially so. What are the statistics in Louisiana?
Well, briefly put, an African American person is 3 times more likely to be arrested for a marijuana offense than a white person in Louisiana. And if you add that up over time, it means more African Americans are not only getting arrested disproportionately to white people in Louisiana, but they're racking up criminal records, which then have an effect under the state's habitual offender statute. And so when you ask about how does this draconian habitual offender statute operate, well, it operates more harshly against black people in Louisiana than white people, because African Americans are disproportionately likely to have an arrest record in Louisiana by virtue of how the laws are enforced in that state.
Considering the disparity between the sentence that he's received in Louisiana and other state laws, especially Colorado and Washington, which have now legalized the recreational use of marijuana, is there an Eighth Amendment argument here that this is cruel and unusual punishment, especially considering as well the hard labor aspect of this?
There's an argument, probably not under the United States Constitution's Eighth Amendment, which has been very narrowly interpreted by federal courts in particular, and so it's unlikely, sadly, that a court would grant relief under the federal Constitution's cruel and unusual clause. However, Louisiana's state constitution has a similar provision, and there is room to argue, and Mr. Noble's attorneys are in fact arguing, that this type of sentence in Louisiana violates the state Constitution's prohibition on cruel and unusual punishments. And we're hoping, just as you mentioned, that the data from other states, many of whom don't punish marijuana possession at all, some of whom, like Washington, Colorado, actually tax and regulate marijuana possession, and others which only provide simple fines for marijuana possession, that type of background information will help persuade the Louisiana Supreme Court that indeed Mr. Noble's sentence is cruel and unusual under the state constitution of Louisiana.
And what is happening now on either a state or national level to try to repeal some of these laws, especially these 3 strikes laws, but the criminalization of marijuana at all, considering the national move towards regulation and taxation rather than criminalization?
Well, what's been interesting in the last couple of years is we've seen a groundswell of movement at the local and state levels across the country of people and their elected officials taking a new look at marijuana laws and marijuana penalties and introducing legislation to reduce the penalties related to marijuana offenses, with Colorado and Washington going the furthest, where you have the whole statewide population voting by great majorities to actually tax and regulate marijuana. And so what we have seen states in recent years do is reduce the marijuana penalties associated with those types of offenses. And we're going to see more of that in upcoming months and years across the country, of various jurisdictions essentially decriminalizing and certainly defelonizing marijuana possession. You know, in this day and age of 2014 of sentencing a person to imprisonment, much less 13 years imprisonment for simple marijuana possession, and somebody who has no history of violence, no serious criminal record, is inhumane on one end and entirely wasteful on another end. And we've got public opinion that fully supports that. And so this case is just crying out for some type of resolution, a different resolution in the courts, the legislature, and the state as a whole.
Daniel Abrahamson is Director of the Office of Legal Affairs for the Drug Policy Alliance. This has been Left Voices for Thursday, April 17th, 2014. You can help support this experiment in independent journalism by visiting our website at www.leftvoices.net and following the Ways to Support Left Voices link at the top of the page. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.